Well, welcome to another episode of the Scriptural Mormonism podcast. I'm your host, Robert Bolin. We're joined by my friend Travis Anderson, or the infamous Ryan, if you're a certain pastor in St. George, Utah. Hi, James Hazelton. Just in terms of announcements, I'll actually share my screen. There's a few things first news is, as you can see here, Maximum America. I will be flying out to the States on the 2nd of December. My visa has been accepted, so on Friday, 2nd of December, I will be flying over. I'll hopefully be collected by my friend Chris Davis. So there might be a bit of a hiatus for a few weeks while I get things sorted in the States, but hopefully we'll be back to normal podcasting in late December, early January. So if there's like a few weeks of a gap, you know why. Now today's episode is actually going to be on the church and the Respect for Marriage Act. The church on the 15th of November, so 5 days ago, issued a statement about this particular issue. So in the show notes, I'll include the church's statement on this, as well as Congress.Gov's brief summary of the Respect for Marriage Act. And to give an example of this in polemics, this is an example from everyone's favorite PhD, who has the receipt to prove it, James White. My dear Mormon friends, your church is literally this. You know how much it has changed in the past 30 years. Now it is literally endorsing the bill that would enshrine the profanity of marriage as seen in the absurd and childish Obergefell decision, all for the promise of religious freedom protections. So, yeah, that's an example of some of the polemics recently. So Travis has kindly come on because he's actually read the legislation, and he actually also has a relevant background as well. So before we kind of discuss this, Travis, thanks for coming on.
Oh, no problem. I love having discussions with you, Robert. It's always fun.
Okay, you've appeared on a few streams, but like maybe if you were to give like maybe a brief introduction to who you are, your background, and also what makes you qualified to be able to discuss this kind of legal issue.
Yeah, so previously when I appear, it's usually for comic relief, so which I always appreciate the interaction. But for purposes of today, I'm actually an attorney. I practice law in Texas, and I do practice in the area of family law, which has been drastically impacted in most states, especially conservative states, as a result of some of these recent Supreme Court decisions. And so you kind of have to understand how they are and the fact and how they impact a family code. And so that's kind of what I wanted to discuss. I think that a lot of people, James White, for example, that's a ridiculous post because it betrays an ignorance of the history of marriage in this country, and certainly of the church's dual mission, which unfortunately you'd think that the church would remain singular in its perspective, which it does, which is to bring souls to Christ. But it also has a dual mission in that it is trying to enforce and support religious freedom and principles so that we can continue to carry out our sole mission of bringing souls to Christ. But also, we are supposed to be subject to the law of the land and be good citizens of the nations in which we reside. And so those two things sometimes create what appears to be disharmony. And unfortunately, the apostles and the prophets of the church have to kind of negotiate that. So I think that if we talk a little bit about the history of marriage and what marriage actually means in society, I think that would be helpful.
Yeah, I believe you actually have a PowerPoint presentation you prepared for us. So if you want to share your screen.
Yeah. So I'll go ahead and share my screen. Again, it's nothing real profound, just kind of something I slapped together to make sure that I'm not rambling. I just kind of wanted to start off with this statement from the Public Affairs. This was put out a couple of years ago by Elder Wickman and Elder Oaks. And in the process of just kind of addressing marriage. And one of the things I liked about this statement is it says, would you extend the same argument against marriage, the same gender marriage or civil unions, or some kind of benefit short of marriage? Elder Wickman said, one way to think of marriage is as a bundle of rights associated with what it means for two people to be married. What the First Presidency has done is express its support of marriage and for that bundle of rights belonging to a man and a woman. So that's one of the things that the church is trying to do is skate the legal and the social implications of the word that we call marriage. Marriage as a term has existed for centuries. I mean, so we've all had marriage for many, many years, and it's the idea of putting together a man and a woman. Now, initially, back when we were all slugging through society for the purposes of just trying to keep ourselves alive and keep our offspring alive, there wasn't a lot of complexity. But as humans have become more socialized and civilized, and we've created communities, laws, civilizations, countries, and states, the idea of marriage has become much more complicated because it has far more implication than simply a person loving another person or two people engaged in a procreative act to create offspring. The biblical idea of marriage, the scriptural idea of marriage, is one man and one woman, and that's the default, is a monogamous relationship that is purposed for multiplying or replenishing the earth. And in the process of doing that, you facilitate a bond of love between the married couple, and they work together to support their offspring. And I think that's the goal. And so the first presidency, when they issued the Proclamation on the Family in the mid-90s, was trying to enshrine that in our doctrine and provide what amounts to a summary of our position on gender, sex, and the marital relationship. Now, what it also states in this, it says the first presidency hasn't expressed itself concerning any specific right. And I think that's important in this statement. And one of the things I think that people watching this need to understand is a lot of what the church does when it produces statements, from a legal perspective, they're done very carefully. The church picks and selects its words very carefully. And it does so to make sure that it maintains clarity in what they say. I think where a lot of criticism arises, and I don't think just in this subject, but in a lot of subjects, is people play fast and loose with what was actually said. And as Robert would probably say, as he discusses theology and religious history with people, as he goes through the texts, he often does, they're playing fast and loose with certain terms. And what makes that difficult when you're talking about the biblical text is you've also got a language barrier, because you've got texts that were written in languages and in cultural contexts and perspectives that we don't often understand in a Western society. But that same principle applies to marriage. I think people just assume that whatever their generic understanding of marriage is the right answer and the right definition of marriage, but it's not that simple. And the first presidency is trying to say, look, we appreciate, on behalf of Elder Wickman, on behalf of the church, is speaking out and saying, look, the first presidency recognizes that marriage is a bundle of rights, and we're trying to enforce all of those rights as they relate to specifically a man and a woman. But unfortunately, doing that is going to bear a lot of difficulty because of the nature of those. So what he does conclude, Elder Wickman does, and it's supported by Elder Oaks, and this is the link for those of you who want to look this up. It's actually a really interesting interview. He says that is something which our doctrine simply doesn't require. When they're trying to rename a marriage, calling it a civil union or something else, and they're trying to use that to defeat the form and function from a religious perspective, and again, important, a religious perspective on marriage. He says that's not right, that's not appropriate, because for purposes of kind of dialoguing, we have to separate out religious institution of marriage and legal marriage. Those two things have different meanings. And Robert could speak to this as well, is this idea of, in the church, we actually have different terms for different kinds of marriage. So we have temporal marriage, we have eternal marriage, which we call sealings. And so within the church even, there are specific types of unions between a man and a woman that exist in our doctrine, and those have to be, the nuance and the complexities of those have to be properly understood to discuss them. So in looking at this bundle of sticks, effectively, which is actually a common legal term, we often refer to a lot of things that have multiple rights as a bundle of sticks. But in looking at that, marriage accomplishes several different things. Now, traditionally, historically, marriage was not really concerned with love between two individuals. People didn't go out dating. I mean, you go back centuries, people didn't go to a local meeting place, meet another person, date, fall in love, and then get married. That wasn't how marriage was done. Marriage was a practical institution that accomplished several things, but among them was it joined and connected families. So families in power, families that were seeking to accomplish some objective, families that were seeking to increase their holdings, their land, expand and increase their influence in society, would often arrange marriages and join people together for purposes of strengthening those bonds. Marriage creates a foundation for procreation because, again, going back to that original purpose of joining people for the purposes of advancing and furthering the family unit and expanding and increasing its endurance in society and in history, they would want to have a progeny to come out of that marital union. So you would want to make sure that the two people that you selected and joined together would have a strong family identity through their posterity. It also identifies who owns property. Marriage specifically can say, look, I own this and you don't. And it identifies heirs to property, and it identifies succession, marital rights, and the marriage relationship as it was accepted from a legal perspective tells us who owns what and why. It can protect titles. So people have a specific title or other component of their identity that they want passed down. Marriage can identify, and marriage laws can identify who owns those. Now, in law today, we identify that it protects the rights of children. Every state has its own family code. And I want people to understand that marriage is traditionally one of those institutions that legally is relegated to the several states to make their own determinations. The federal government interfering in marriage is something that a lot of especially conservatives are pretty scared about, because anytime the federal government identifies something as a right, it tries to interfere in the state's abilities to govern that right. And that's why as you pass between different states, you'll find different laws governing the marital relationship, the distribution of property, succession, heirship, things like that will be different state by state. But remember, the reason that's appropriate is because of this third principle, which is marriage identifies who owns land. So when it's talking about property, it's talking about real property. Who owns the land? And consistent with that also is the finances or the income that can come from that land. That was a very big concern. So anybody who owns land in Oklahoma or in Idaho or even in any country or state, that land doesn't move. The ownership of that land can be held by a person who can transfer their own citizenship, but the ownership of that land would remain with the state and the jurisdictional boundaries. And that's why marriage, which is predominantly concerned with property rights, will maintain those rights within a particular state boundary. Having the federal government dictate to Oklahoma or to Florida who owns the property within their state boundaries is just simply inappropriate. But there can be federal implications with that. So again, that's why a lot of marriages historically were arranged, because these are very important issues. And historically, people felt that the state should be involved in making those kinds of decisions. And so marriage was adopted as the principle through which people could determine those things under the cover of law, rather than having individuals decide those things. If you're going to live in a in a civilized and polite society, then certainly you have to decide who owns what and why. And marriage was just an avenue for them to adopt to do that. Nowadays, because society has distinguished itself from the past, and we no longer rely on arranged marriages or the state telling us how marriage is supposed to function, these ideas seem very odd. And the support for these ideas seems silly in our estimation, because we have taken our emotion and we have interjected that into the marriage relationship. So, for example, I chose my wife. I went out, I met people, I dated, and I found somebody that I liked. We dated for a while and eventually decided to get married. As a person who was raised to be gentlemanly, I asked her father for her hand in marriage, knowing that he would probably give it to me. But it wasn't an arranged marriage. My parents didn't get together with her parents and decide to marry us to unite our families and unite the clans, as they say. That wasn't really the purpose of it. We loved each other and we wanted to form a life together and have the freedom to do that. And the United States and most of modern Western society recognizes that. Now, that's not consistent across the globe. And speaking of that, the church has to be sensitive to that issue as well. And that's one of the other problems that I see with a lot of the media reporting on the church's positions on marriage, is they almost ignore the fact that this is a global church that actually has to navigate the complexities of international law, not just the laws in the United States. So even though we do adopt a lot of our ideas from the English common law, that doesn't mean that the UK and the United States have the same perspectives on law. Now, gradually over time, religious and social conventions have interfered with marriage. So God's pattern for marriage, as it's understood in Genesis, for example, with the joining of Adam and Eve, from a Latter-day Saint perspective, Adam and Eve were bound together for eternity. The idea that they would upset that union through some kind of divorcement or divorce proceeding or separation, that wasn't really contemplated in those texts. When people got married, especially in these arranged marriage situations, the idea that you would separate or break up, they just didn't. I mean, and that's why even, people look at Henry VIII and his alleged kind of issues with trying to divorce his wives and having a break from the church as a result. Whether that's true or not, it doesn't matter. But the point is that those institutions, breaking up those bonds that were purposed for uniting homes and governments and people and family and lands and things, just because we don't like each other, that was just not something that was contemplated. And so Christ kind of reiterates that original law in Matthew 19:3-9, when he says that the Pharisees came to him, tempting him and saying to him, "Is it lawful for a man to put away his wife for every cause?" And he answered and said to them, "Have you not read that which was made them at the beginning, made them male and female? He said, for this cause shall a man leave father and mother, and shall cleave to his wife, and the twain shall be one flesh." That is the standing law of God as it exists in a religious context. And yet, religiously, most churches, most faiths, most traditions accept divorce as a potential for ending a relationship. Now, as long as there's going to be social interjections on a religious context for marriage, religions cannot maintain these high levels of, our religion is what governs marriage and blah, blah, blah. So James White's entire comment that you kind of cited earlier is silly because it presupposes that there's no societal impact on marriage that could ever be relevant. And that is nonsense, because even James White would probably say, well, divorce is okay in some situations, but really that's not the standing law of God. God doesn't want people to be divorced or separate. He wants them to work through their problems and remain together. That's God's plan. That's God's provisions. And so if people are going to legally provide a remedy in the form of a divorce, there also has to be, again, this bundle of rights has to be considered not from a religious perspective, but by the state. So you're basically, by engaging in social conventions like divorce, well, you've just invited the law in, and you've invited the state to interject its opinions into your relationship. You can't go back and say, okay, marriage is only between a man and a woman. Okay, fine. But now we're going to divorce people, because now what that does is that creates situations where who owns the kids? Who gets the kids? Who supports the kids? Because remember, you're not together anymore. Who owns the property that you got together? Who gets the income from the source of income? Does a spouse that remained home to take care of children get punished because the other spouse was the primary breadwinner? Do we leave that spouse with nothing? Is it right to just give the kids to dad because he was the one with the money? And so society had to kind of contemplate these deep and complex questions, and so must a church. Unfortunately, they're parts of society, and we must contemplate them and we must consider them. So properly, in advance of the separation of church and state, the church can hold its own religious views, namely, as you indicated, with the church's position in this most recent statement. And I'll go ahead, let me find my slide that has that in there. So it says here, this is the statement that was released. It says, the doctrine of the Church of Jesus Christ of Latter-day Saints related to marriage between a man and woman is well known and will remain unchanged. Again, referring to our doctrine. This is not regarding the law, the principles of law, how the law interacts with it, because the Church also tells us in our Articles of Faith that we should be good citizens, that we should be subject to king, rulers, presidents, magistrates, and honor and obey, sustain the law. So the Church has to walk this tightrope between these two principles, which sometimes appear at odds. And if you're not paying attention to the complexity of these arguments, what happens is you start to see contradictions. But it's not the Church that's being contradictory. It's the Church is maintaining its position from a religious standpoint, and it's trying to say, okay, but here's what the law is requiring of us. So how can we obey this law and yet maintain our principles? Well, one of the ways that we can do that is by making a statement saying, look, our doctrine remains unchanged. Marriage is between a man and a woman. But there are more bundles of sticks that have to be considered, and those are relegated to the state. And so the Church is trying to navigate that. Now remember, many of the leaders of the Church are legal scholars, legal minds, and they have the same knowledge and training that I received in the process of my own education and practice. And so they understand these issues. This is not just like dumb guys coming up with conclusions and making stupid decisions without thinking them through. These are educated people who are trying to ponder and consider the best ways to move forward. So one of the things that's principle in our church is, and from the Book of Mormon, is that men are free according to the flesh, and all things are given them which are expedient unto men. We get to do what we want. Now, within the confines of the consequences of our actions, we get to choose. Now, I like this passage because it then goes on and says, they're free to choose liberty and eternal life through the great mediator of all men, or captivity and death according to the captivity of the devil. So the process is that the idea is that there is more at stake here than simply identifying whether or not same-sex marriage is acceptable to the church. The fact is that some people have chosen to accept a certain relationship that has implications from both a social and a secular perspective and a legal perspective. And yes, religious minds may not agree with that, but we have an overriding principle of we are free according to our flesh. We can choose what we want to do. And that is a principle of the gospel. Men have their own moral agency to choose what they would like to do with their own selves. And so now we have a lot of nuance with respect to that. And obviously, we believe we're in submission to God, and we should be, but that is a religious idea. That's not a secular idea. So what is family law? Well, so as I stated, all states have their own family codes, their own family law. Family law encompasses those laws which try to prevent or resolve common disputes arising from the natural functions of families. So as an attorney who practices in this area, I've got to kind of, when I navigate these issues, one of the things that I serve as specifically is I serve as a mediator, and I try to resolve these conflicts between parties. And so as I do that, I get two attorneys who are disputing or arguing over these several issues. So there's procedures for forming and dissolving a family. So even what is a marriage has to be legally identified, because if you don't specify what marriage is, you can't go through those other bundles of sticks and separate out and understand the complexities of those rights. So sexual relations in the marriage are also identified in family codes. Parent-child rights and responsibilities, economic support of family members, because sometimes not just children, but there are people who are mentally or physically disabled who must be cared for by the resources that are created in a marriage relationship. So saying something like, oh, marriage should only be between a man and a woman. Okay, that's great. But what do you do when a husband and a wife marry, have a child, the child has Down syndrome or some other mental difficulty, can never care for themselves in a meaningful way, and there's adequate resources in that marriage to care for that child? Well, what do? Let's say one of the parents decides to become homosexual and they engage in a relationship, and the other parent dies. And so all of these things can become complex because now you've got a husband or an ex-husband or ex-wife who have now engaged in a same-sex relationship. The other parent is dead, and now you have this disabled child. Well, let's say that the other partner in that same-sex union wants to adopt that child who now only has one parent. Should church say no when the state says our overriding interest is the care of the disabled person? And if somebody is willing to step up and assume that responsibility, legally, what's your problem with that? Now, from a moral standpoint, Latter-day Saints may say, well, our brains kind of go into this weird place where we start to say, well we shouldn't have, and really the answer is from the secular state position. We're saying, look, the more the merrier. If people want to take care of people and they want to provide financial and other support for somebody who is of diminished capacity, and that could be a child or somebody with some form of handicap, what's your problem with that? And so the actual problem in the relationship was created as a result of the choice of the individual. That is the moral question, not the consequences that occur after that moral choice has been made. So the partner in that relationship's choice to engage in a same-sex relationship has created an issue which the law now has to determine. So where the religion should do is, the religious perspective is, same-sex relationships, we believe, are sinful, especially because they violate our law of chastity. Okay, that's fine, but that's where your commentary ends. Now, whether or not two people should engage in sharing some of their bundles of their sticks to try to take care of somebody who's in a diminished or capacity, legally, the law is going to say, well, we don't have any issue with that because we're not a religious institution. This is the law. And so that is some of the complexities that can happen. Early on, it was such that, and in some states it still is, that in states that aren't what they call community property, but when a man and a woman marry, I mean, we just take for granted that if the husband dies, the wife gets his stuff. Or if the wife dies, the husband gets its stuff. But the law doesn't always say that. In some states, that's not the case at all. When the wife dies, or the husband dies, their property passes to their children, not to their spouse. And if the law doesn't figure out some way to ferret through that stuff, these divisions of property rights become incredibly complicated and can create fights. So the purposes of family codes is to codify, to set out rules and principles that help to resolve these things so that we don't engage in an emotional fight over land, property, or who takes care of children. Those are really complex issues that have to be decided, and they cannot be decided from a church. But one of the things that I find is really funny from that perspective is a lot of people view Scripture and they forget the fact that a lot of these scriptures are coming out of theocracies. These are not, a U.S. government. The biblical texts do not reflect a U.S. government type of government. That's a theocracy. You've got prophets and kings who are subject to prophets, who are ruling as monarchs, who are enforcing what they believe is God's law, given to them by prophets. So it's a totally religious hierarchical society. It is not one that is separated into church and state. And that's why the church is sometimes engaging in what look like concessions, but actually aren't. The church is simply identifying the religious principle and maintaining the religious principle and allowing the law to make the commentary based on the legal perspective. And I think that that's really important to understand. Now, in this country, we have two parts of the Constitution that become incredibly relevant to marriage. One of them is the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. This is one of the common amendments that's cited from the Constitution in litigation regarding marriage, same-sex marriage. Earlier, it was whether or not people of different skin color could marry each other, and kind of so-called interracial marriage. So those ideas and those principles spoke of and kind of touched on the 14th Amendment, which guarantees citizens equal protection under the law. And so it says right here, it says, no or deny any person within its jurisdiction the equal protection of the law. So we all have an equal protection that's due and afforded us. And that goes back to that example I gave, where you have a same-sex couple who end up with a disabled person or child that they are willing to care for, and a religious person saying, I don't like that you're in a same-sex relationship, so because of the same-sex nature of your relationship, I do not want one of those people who is willing to love and provide support for the disabled person. I just don't want them involved in it. And so what the state asks, the state says, okay, without making a religious argument, explain why. And if you can't make a legal argument that doesn't touch upon religion, the state will likely reject that argument. And that's where the church has to be very careful in the way that it crafts and it puts its statement. Another portion of the Constitution is Article 4, Section 1 of the Constitution. So the preliminary part of the Constitution is broken up into articles. The first 3 articles identify our 3 branches of government. But Article 4 starts to talk about states' rights. It says full faith and credit shall be given to each state. So this is basically, we have a United States and the states have to work together. So not only do we have equal protection under the law, and that is a federal principle. All states have to recognize that because it's a constitutional principle. But also we have this idea that each state gets to have its own specific laws governing those things that don't touch the federal government. Now, traditionally, states are independent to govern their own, it's family law, their own criminal codes, and their own education codes and things like that. Now, there is some interjection whenever the federal government provides funding for any of those avenues, but for purposes of that, anybody who's ever looked at a criminal case, for example, knows that you can have a state charge for like drug possession, but if you do certain things, you can also have federal charges. So, and those 2 charges are completely disparate in their punishments, in their scheme. I mean, you might go to state court and the judge there sentences you to a couple months in jail for possession, simple possession charge. But the federal government comes in and says, oh no, you violated a host of other federal statutes, and we're going to throw you in jail for 20 years. So when you have a certain type of state interest, federal government can have some interest in it if it touches federal law. So usually if you're transporting drugs across state lines, for example, you can be charged in that way. But so there's a lot of proceedings that occur specific to the state. And if the state makes a decision, they're expecting other states to respect the decision. So if you have a decision made in Florida and you move to California, Florida wants California to recognize what they decided and not just say, we don't care what Florida did. We're going to make the whole case start over again, and we're going to try it under California law. And if that was the case, I can't even imagine the anarchy that would create, where you'd have this situation where people would be state hopping as they get a result they don't like. They just bounce to a state and try to seek a more favorable conclusion or resolution to that, effectively retrying the cases again. That would be just anarchy. So in looking at the actual law, so one of the things, and I don't want to go through this whole bill, but actually before I get there, I want to kind of talk about a couple of cases that are significant. Now, the current legislation that's being proposed, which is passed, I think, the House, and it's now in the Senate. The current legislation that's being proposed is amending something that was declared unconstitutional. So in the mid-90s, under, I think, President Clinton, he signed into law something called the DOMA, or the Defense of Marriage Act, and it identifies federally, from a federal perspective, it says that marriage is only between a man and a woman. Now, at the time, the public sentiment was that made perfect sense. And if you ever want to watch, and I'm not trying to get political here, but if you ever want to watch the way society's kind of transitioned, you can actually watch the statements made by our current president, Joe Biden, as he has changed his own perspectives on marriage. So initially, when he first was running for office with Barack Obama, their position is that marriage was only between a man and a woman. And in the vice presidential debates that he had with the vice presidential candidate for the Republican Party, he stated, she indicated that marriage should be between a man and a woman, and it has a sacred history. And basically her entire argument was based on, it's good for people to get together and have children, and that's what God wants. And in response to that, Joe Biden says, sure, I agree with that. I think that that's correct. But again, that was the consensus across the United States as a whole. The majority of people supported those positions. Now, when I was serving my own mission in California in the late 90s, the initial language of the California Constitution was being proffered as being changed to identify to clear up an ambiguity that existed in the California Constitution, namely that marriage, it just didn't identify what a marriage was, because it was assumed that marriage was between a man and a woman. The idea that same-sex couples could get married was just not something that was contemplated. And as soon as states started passing same-sex marriage statutes and enforcing same-sex marriage relationships and causing them marriages, certain states took issue with that and began to take action. The church, the LDS Church, again, from its religious perspective, enforced, supported, and endorsed legislation that defined marriage as between a man and a woman, but did so as a member of society. You know, the church is a member of society. It has a voice in the public speech. And so from that perspective, it encouraged its members to exercise their own free will and agency to support what they believed was a moral question. And likewise, Latter-day Saints were encouraged to vote in support of legislation that secured the definition of marriage as between a man and a woman. But they did so without much thought for what its legal implications or the complexities of the law that are at issue regarding that question. Marriage is not a one-size-fits-all simple question that can just be answered. It is complex. So what happened is in these states, in these questions, New York, it says in New York, in this U.S. v. Windsor, it's a 2013 U.S. Supreme Court case, and it actually found Section 3 of DOMA, the Defense of Marriage Act, as unconstitutional. And the background of that case is a same-sex couple were married, I believe, in Canada. They moved into the United States. They had lived together for many, many, many decades. I mean, these were people who were probably, I think they were born in the 30s. They died, the first one of them died, I think, in 2010 or 7 or something. But in the process of their death, the other spouse became the heir of all the property of her spouse. So it was 2 women. As a consequence of that, she was taxed because she was not considered a spouse. So she was not exempted from paying the estate taxes because she wasn't a spouse. And so she ended up paying something close to $400,000 in taxes based on the transfer of the estate to her. And as a product of that, she sued and said, no, this isn't right. Our relationship was a marriage. It always has been a marriage. And the state in which that they were located says, no, that's not correct. But here's the kicker. New York at that time treated these relationships as marriages. And so the argument was effectively that under the Equal Protection Clause, you can't federally identify, based on the federal government's taxation system, you can't exempt people in New York from paying these taxes because you're saying that a same-sex relationship is a marriage, and then saying that mine, because I'm in a different state, for purposes of a federal question, which taxation is a federal question, you can't identify me as a different kind of person. Because if you're saying that they're married, I'm married. And that's actually kind of the crack in the door where same-sex relationships kind of walked through, because as soon as any state recognizes those unions, it's almost impossible under these 2 portions of the Constitution, the 14th Amendment and the Equal Protection Clause of the Equal Protection Clause of the 14th Amendment, and under the Full Faith and Credit Clause of Article 4, it's almost impossible not to grant those same protections to everybody across the entire country. You can't have somebody who's in a same-sex relationship where they vote to legalize same-sex marriage in Hawaii, in California, in New York, and then have those people move to Texas or Colorado or Florida or Ohio or some other state that does not have that same statute, and then say, well, as soon as you moved from California to Florida, oh, well, you're not married anymore. Because the legal process that was undertaken in California must be recognized by all other states, because that was a legally binding relationship. And that is effectively what this new legislation is trying to cure. It's saying that, look, we recognize under US v. Windsor that identifying a relationship, a marriage, as only between one man and one woman creates this problem, because as states enact and support same-sex unions, which voters were more than willing to able to either suppress through voting against it or enforce. But once one state passed it, now you have US federal implications and the Constitution becomes an issue. Because again, the law doesn't care about what your feelings or your relationship is. What they're looking at is they're looking at who owns what and what were the people's beliefs when they entered into that relationship, and how should the government distribute the products, the property, the finances, the money, the children, the obligations, the rights that come out of those relationships. How should those be treated under the law? Well, obviously, most people would probably say, well, they should be equally protected for all people. Even though you don't like same-sex marriage from a religious standpoint, the U.S. government is forced to support and reinforce those kinds of claims. So that's what was really found in U.S. So more recently, in 2015, Bridgeville v. Hodge, which is the case that James White says was poorly decided. You may not have liked the conclusion, but the great thing about being a lawyer is lawyers are very careful in the way that we pick cases, especially if we're going to take them to the U.S. Supreme Court. Lawyers who take cases to the U.S. Supreme Court and through appellate system and through the federal system usually do so based on a very carefully selected issue. They're trying to enact some kind of law from the bench through the judiciary. And so the issues that they're going to litigate, they're going to carefully decide which issues they pick. And they're going to pick really good cases. So this is a really good case for upsetting the idea of outlawing or banning a same-sex union. If you're trying to fight that decision, this was a good case to have picked. It has some very, very complex issues regarding the people. So it says here, Bridgeville and Arthur decided to commit to one another, resolving to marry before Arthur died. To fulfill their mutual promise, they traveled from Ohio to Maryland, where same-sex marriage was legal. Again, going back to the full faith and credit and equal protection clauses. And so it was the 14th Amendment, the equal protection clause, that they were trying to say. They're saying, well, look, federally, we're married in that state, but when we're in this state, we're not married? How can that be? Because what happened as a result of that is one of the spouses died, Arthur died. Ohio law does not permit Bridgeville to be listed as the surviving spouse on the death certificate. By statute, they must remain strangers even in death. And so what happened is that they picked a case that created a very complex issue with regards to their relationship, and they litigated it from that perspective. Because if one state says, yes, you can have marriage, well, how do you reconcile the equal protection clause, which the U.S. Constitution says when people have rights, they have rights across everywhere? Are you arguing marriage isn't a right? Because the U.S. Supreme Court had previously determined that marriage was a right in other case laws. So the idea that social changes had kind of led to that. So initially, this is kind of a contemporary part of the case where it discusses the society's transitioning perspectives on same-sex relationships. Initially, homosexual relationships were just illegal. Well, I don't believe that a homosexual relationship should be illegal, regardless of my moral perspectives and regardless of what I believe God has revealed to us regarding those relationships or the purposes of heterosexual relationships. I don't believe that we should criminalize people for their behaviors in that way, private behaviors that don't cause harm to other people, for example. And that may sound like a very liberal perspective, but that's a legal perspective. There's no harm undertaken if two people want to be romantically involved in the privacy of their own home. That doesn't have anything to do with me, and it doesn't harm me. And so this, regardless of how I think it might affect society in the long run. But see, so what happens is that they go in and they kind of show that legally it was criminalized. It says they upheld the constitutionality of Georgia law that deemed to criminalize certain homosexual acts. 10 years later, in a subsequent case, the court invalidated an amendment to Colorado's constitution that sought to foreclose any branch or political subdivision of the state from protecting persons against discrimination based on sexual orientation. Then in 2003, the court overruled Bowers, holding that the laws making same-sex intimacy a crime demean the lives of homosexual persons. Again, simply because two people want to engage in some kind of affection towards one another, the courts have determined that the only argument against that would be a religious argument. It would not be any kind of legal argument that could be proffered. And so it's really important to understand that legal arguments, for example, would be, and if I was arguing Bridgeville v. Hodge, and it's one of the arguments was actually made in the case, is the government, the federal government, supplies certain benefits, tax benefits and things, to people who are married. Under certain levels of scrutiny, the federal government might want to limit who gets those benefits, as it does with benefits like Social Security. So if we make it where any relationship between any people, any two people, three people, four people, is a relationship, because if you're going to allow marriage to have an open definition, why not allow any relationship that people want to call a marriage to be a marriage? And that's where you get kind of these jokes of, well, why can't marriage be this or that or the other? So in looking at those perspectives, the complexities become, well, if we're going to broaden the definition of marriage to include whatever we want it to be or whatever people feel like it is, what you could do is you could end up expanding the benefits that are provided to people under the federal government, and under, like the tax and spending clause of the U.S. Constitution, Congress can limit who gets certain benefits, for example. So that would be an argument you could make that is not a moral argument regarding a same-sex marriage. But those arguments are more difficult to make, because it sounds like you're trying to curtail somebody's civil rights for purposes of advancing a religious motive. And I think that the court found that. So from my own moral perspective, I disagree with decisions that recognize same-sex marriage as being equivalent to a heterosexual marriage. But from a legal perspective, when I put on my lawyer hat, I have to recognize that the legal complexities require us to be understanding in those regards. So, for example, Alma chapter 30, verses 7 through 11 kind of indicates that that's the case as well. So I don't think the First Presidency's recent statement is something that is so different from what we have in our own scriptures and what's been involved in I mean, if you want to say, oh, the Book of Mormon's not scripture, that's perfectly fine, but for purposes of our acceptance of our own faith tradition, our own development of our own theology, the church's position on this issue has been consistent. So, for example, in Alma 37 through 11, it says, "Now there was no law against a man's belief. For if it was strictly contrary to the commands of God that there should be a law which should bring men on an equal grounds. For thus saith the Scriptures, choose ye this day whom ye will serve. Now if a man desired to serve God, it was his privilege. Or rather, if he believed in God, it was his privilege to serve him. But if he did not believe in him, there was no law that could punish him. But if a man murdered, he was punished unto death. If he robbed, he was also punished. If he stole, he was also punished." Now here's the issue. If he committed adultery, this law, which existed in a theocratic society, would have been reinforced. But we do not have a theocratic society. We have a secular society. And so with that said, the idea is that adultery and other acts have been decriminalized, has been replete throughout U.S. law for many years. And so we no longer have so-called laws that make such acts unlawful. We've kind of removed that from the public. Laws regarding sodomy and things like that have been removed from books or just simply aren't enforced. But so that's the only argument you could make from this text. But again, it's a religious argument. These others, if a man murders, obviously murder is a crime. If a man robs you, takes away your property, that's a legal argument. You can't take away something that doesn't belong to you. But the adultery aspect of this becomes more of a theocratic argument, more of a theological argument rather than an actual criminal act. For there was no law that could be judged according to man. Nevertheless, there was no law against a man's belief. So if a person wants to believe whatever they want to believe, I believe that Alma 37 through 11 would support that, and I believe that that's the church's position as well. The church is trying to say, look, we understand that adultery That has moral implications. Religion. The law of the land is that that is no longer a crime in most jurisdictions. And so we're going to honor and respect that. We're going to still preach against it. We're going to say that God condemns those behaviors, which is the primary reason why the church still condemns homosexuality, because it violates our law of chastity. But the law, of course, reinforces people's ability to believe what they want and to choose what they want, as long as they aren't engaged in criminal activities. But what's considered a criminal activity is going to be determined at law, not purely by a theological or religious institution. So going back to Bridgeville, it says, finally, it must be emphasized, this is what the language that I think that the case actually states that I think is good. It says, finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with us most sincere conviction that by divine precepts, same-sex marriage should not be condoned. First Amendment ensures these. So even in Bridgeville, despite religious conservatives not liking the fact that it legalized same-sex marriage, the language, the dicta in the actual decision actually reinforces and supports religious context. It divides the two properly by saying, look, we're making a legal decision under articles, under the 14th Amendment and Article 4 of the U.S. Constitution. We're not making a moral argument. We're not speaking as to whether or not homosexual relationships are moral or immoral or whatever. We're trying to say, look, people engaged in certain conduct must be protected because the consequences of their conduct have implications that go beyond simply whether or not you think it's moral, whether or not you think it's adultery. Because people accumulate property. They accumulate rights, not only in their property, but in the lives of other individuals. And from that perspective, the church has to be careful because it would overstep its bounds by saying, look, we don't think that you should support the laws of your land. We don't think that honoring and obeying and sustaining the laws of your land is appropriate. And so what the church would say is, look, well-meaning people, which is what this clause, this dicta in the Bridgeville decision says, if you want to keep petitioning your government to do something about that, go ahead. That's your legal right. The church would say, yeah, that's your legal right. That's your position. Now, from those perspectives, though, if you go to what the church has specifically said, so this is from President Nelson. Well, this is from the church's statement on same-sex marriage. It says, changing the civil law indeed cannot change the moral law that God has established. Again, correctly identifying the church's position as God's moral law, not the law of the land, not the laws of the Constitution, not the laws of the state government, but the laws that God has established, which is the church's prerogative as a religious institution to enforce and support. God expects us to uphold and keep his commandments regardless of opinions or trends in society. His law of chastity is clear. Sexual relations are proper. This is the church's doctrine. It's always been the church's doctrine. The church has never retracted its positions on these, but has continued to reassert them and reinforce them. This statement that was issued on the 15th of November does not do anything different. It says the doctrine of the church, again, not the laws of God, not the laws of the United States, not the laws of the Constitution, not the society of decisions, but the doctrine of the church remains, or related to marriage between a man and a woman, is well known and will remain unchanged. We are grateful, specifically, this is really, really important language. We are grateful for the continuing efforts of those who work to ensure Respect for Marriage Act includes appropriate religious freedom protections while respecting the law and preserving the rights of our LGBTQ brothers and sisters. The church is not saying we support gay marriage. It's simply saying all human beings have rights. And we're grateful for laws that support all people's rights. Do not single out or treat as other people. Those are wrong. Those would be inappropriate laws. The church would not support that. We don't otherize people. Christ in his mortal ministry reached out to the disaffected. He reached out to those who were abused and who were cast out by society. And as Latter-day Saints, we should not do that either. The church is not trying to do that. I think that from my perspective, what James White is advocating is bigotry. I think that when you go in and you say, look, the rights of gay people should be trounced on or not recognized simply because they're engaged in what I believe is sinful behavior. If that was the case, everybody is engaged in sinful behavior to some degree. So should we lose our rights under the Constitution because we're sinners? I don't understand the logic and the reasoning regarding that situation. It doesn't make much sense to me. We believe, and he says, we believe this approach is the way forward as we work together to preserve the principles and practices of religious freedom together with the rights of LGBTQ individuals. The rights that have been recognized are common and they are universal throughout most states. For example, we understand, again, going back to the beginning of my kind of diatribe here, is the idea that people engage in marriage. And as long as people are going to kind of to be a little crass about it, they're going to screw that up by getting divorced, by separating, by ending their marriage relationships, which God doesn't want to happen anyway. Well, now you've created a host of other problems that society has to deal with. Now, society's way of kind of putting a Band-Aid on those things is kind of what Jesus was saying of, this was not the case from the beginning. Because you guys don't listen to God, because you guys create these problems, okay, well, now you've got to create laws to fix those problems. So people having children out of wedlock has created several problems. We have a group of kids who are without parents, who are in the adoption system. We have groups of mothers who want to end their pregnancy. So now you've got an issue with adoption and you've got an issue with abortion. Those are societal issues that shouldn't be created if people would honor and obey God's standing law of chastity, but they don't. So what do you do with the problems? Well, you keep teaching God's law of chastity, and then the law has to make remedial decisions to try to reflect and protect the rights of the children who are affected by the poor decision-making of adults. And the church recognizes that, and I guess, and repeatedly reflects that. So in looking at, let me kind of end this screen share real quick and share the actual text of this, the law here. Let's see where to put it. So in looking at that, the church is focused on not, so if you read this very carefully, this is what was proposed for the Senate in what the church is supporting. This is simply removing, for example, the portion of the DOMA that was declared unconstitutional in 2013. That meant that even though that sat on the books, it wasn't constitutional, it couldn't be enforced. And that's the idea that marriage is between a man and a woman. Windsor and Bridgeville both found that unconstitutional. You can't enforce that, so they're removing that. It then reiterates the idea of the full faith and credit given to marriage equality, because some states have passed laws that allow for same-sex marriage. They're on the books. Texas, for example, we still have a law on the books that says marriage between a man and a woman is void. That's our law. But that law is not constitutional and can't be enforced. So under some laws of some states that have decided and determined amongst those individuals to enforce those, if those married people in California or New York or Hawaii or other places that have added that as part of their law are enforced, then what happens is if they move to other states, are they still married? And under the federal government's umbrella of protections, under the Equal Protection Act, I would say the question would have to be answered in the affirmative. Yes, the federal government should step in and enforce and support their rights as they move between states, because the ability to ingress and egress between states is also found in our Constitution. We can't just say, okay, if you're going to live in California and be married, you have to stay in California. That's just contrary to the idea of a united states and the states working together to advance the affairs of its citizens. So full faith and credit is given to those. It's codifying that principle. It says certain acts, records, and proceedings in the effect thereof, no persons acting under the color of state law may deny. So full faith and credit to any public act, judicial proceeding, or other state pertaining to marriage between two individuals on the basis of sex, race, ethnicity, national origin, or those individuals. Now, this language, I think, is ambiguous enough that I think it's clearly an expansive language rather than a conclusory language. So calling this the so-called gay marriage law or whatever they're calling it, I don't know that that's necessarily appropriate. It's simply just recognizing that people who engage in what we now term as marriage, which doesn't have a clear definition as much anymore, that those persons' rights should be protected. Again, for all the reasons I've outlined. When people engage in relationships, they create property rights. So what the church is supporting and what the church does speak to as something that is important in this thing is it says, no impact on religious liberty and conscience. So this is what the church is declaring. Look, we're grateful that they're not making this protection so broad as to force religious institutions to violate their moral conscience or principles and support what they believe is behavior that is contrary to their religious conscience. And I think that that's appropriate. I think that the church is supporting the efforts and is identifying the distinctions between how a religious organization and religious people view marriage and how secular society with its many complexities and laws has to view and adopt marriage. People just don't really reconcile those two things and see them as separate. They are two different hats. They're two different things. They have to be analyzed differently. When we talk to people outside of our faith, often there's this, and I think that a lot of Christians make a mistake when they're debating, for example, theology, and they're trying to put on a objective hat of, I can prove the Bible is true because of archaeology and science. And they kind of are overstating and overclaiming something. And what they're doing is they're stepping out of the epistemology of a religious context, and they're stepping into a scientific epistemology, which if they keep going down that road, anybody who's against the idea that there's a God is going to trounce all over those arguments, because you're trying to conflate two different kinds of knowing. And I think in this context, you have a legal perspective and you have a religious perspective. And while those two things seem not to align, which in our society they don't, you still have to evaluate them based on their specific criteria. So that's, Robert, that's kind of what I wanted to kind of say.
Oh, no, that was very good. I think that kind of covered a lot of the important issues that will come up, and a lot of the things that are not actually taken into consideration by critics, whether evangelical conservatives or like the regressive progmos who think this will mean gay marriage and so
yeah, I mean the church has never said that.
Even in the official press release, it basically says it acknowledges marriage as heteronormative. It doesn't actually acknowledge the validity of gay marriage and things like that, at least theologically. Yeah.
Well, just real quick, I want to show us one more little quick slide. This is what's funny, and I made this meme the other day. Prophets have taught this, but some members of the church think that they're teaching this. It's just this idea that you're like, when have you heard prophets not say love, affection, consideration, respect, those kinds of things for people of all faiths, all beliefs, because that's what Christ taught, to serve and help others, not to, let's go hate gay people.
Yeah, with of course the caveat, and I know you're not saying this, but when it says love people, loads of people just think that means accept them as they are and don't call them to repentance.
Right.
There's one person, and I'll name him Anthony Miller, who basically I know he'll say otherwise, but the reason why he jettisoned the church is because his son came out as gay and is supposed to do the genuine Levantine and call him to repentance and tell him to strive against sin. He basically accept the sinful lifestyle he lives. So well,
it's just this idea of my job as a follower of Christ is not to make you comfortable, right? And that's what I think people think. They're like, okay, so if your child, if a family member, if a brother or sister or something came out as homosexual, you're supposed to, never say anything about it, or put on your pride hat and go out and march with them. There's nothing that says that. If one of my siblings or children came out as gay, I would still hold the same position I hold today. I would love my children. I just love my children. But I'm not going to say, okay, because you're gay, being gay is okay.
Yeah.
That's just not, it's just, I don't know why people can't keep things properly separated when they are intended to be separate. And I just don't get it. And the articles, so one of the things that I've noticed, and I just want to touch on this, and I had some screenshots, which I don't know where I put them, but of the articles from the New York Times and the Washington Post and other outlets, LDS Church endorses same-sex marriage. I mean, that's just not what's happening.
Yeah,
and so a lot of the flashback has been that.
Some Romanist on Twitter, he goes by John Fisher. He's from Canada, but I think he's like part Lebanese. He actually tried throwing that out against me. It's like, that covers up like the lack of icon veneration, the opening centuries of Christianity. But yeah, I think it was a Washington Post article. But yeah,
I just don't. And it sounds like. And where I have a hard time even making these arguments is that it sounds like I'm trying to keep two things separate, that you're trying to push together, but there are just things that don't fit. They just don't work together. So, I mean, if you, even as a Christian, as somebody who believes in the Bible, for example, there's different ways to view the Bible and still be a Christian. There's perspectives you can hold on the texts that are okay and are appropriate. But where I have a hard time is as people try to say, for example, the Bible is dictated by God, and then also try to argue the scientific perspective to support the authenticity or veracity of those texts, when it just reflects that I don't think you really looked into that very deep. So let's not make scientific arguments on religious claims, just like let's not use a legal argument to try to argue theology. Now, as a lawyer, one of the things that's really drawn me to study theology and religion is when I read the Bible or read the Book of Mormon, these are legal texts. These are documents that reflect how a society organized itself and enacted laws for its people. But I properly recognize that those texts are from a different kind of government than what I appreciate today. Now, as the Book of Mormon kind of transitioned into the reign of the judges, I think it became a little bit closer to what we've got today, but is completely different in many respects. It's not like U.S. society. Your system there in the UK is completely different, even though we borrow from English common law. So these ideas of analysis being consistent across different genres or perspectives is just silly. And once you do that, you've really overclaimed. And I think that you're going to end up shooting yourself in the foot in that respect.
That's good. Anything else you want to add to this? Either as someone who has a background in law, or just as someone who's like who's LDS, who's been looking on the mess
just
that's been social.
Yeah. So one of the big. So I do a lot of adoption work, and I love it. It's I do mediation where I help people to kind of resolve their marital conflicts, and I do adoption. I do divorce, but I try to really focus away from that. I don't like it. I mean, nobody wants to be the guy that breaks up families, but I understand that that's necessary. There's a lot of settings in which a divorce is unfortunately a necessity. The actions of one or two of the people have just created that situation. But what's really nice and what's really great is when you adopt children. And I think that my example of, and it's a real example that actually I can actually cite to as an example where a couple had a child. The child, as they aged, was developmentally disabled and could never care for themselves. And the two parents were working together to provide support and care for that child. That child's now an adult legally, but mentally can never be an adult. And somebody stepped in and decided to, after one of the ex-spouses died, the parents died, they decided to assume the responsibility to adopt that child. It's hard to condemn somebody regardless of why they're doing it for wanting to do that. And the law to be able to say, look, imagine this, a woman who's caring for somebody like that decides to become same-sex attracted and is same-sex attracted and gets together with another person that's like-minded. That person falls in love with that disabled person and decides to care for and take care of and invest in the life of that person. And then the other person dies. And now the person who is not that person's caregiver or biological parent and has no more access to the assets, the estate, the ability to care for that person. So is it better that that person now be just placed in state custody, in state? I just, if somebody's willing to step up and do something like that, why would the law tell them no? And I just think that has a lot of moral implications. Do I agree with same-sex relationships as a result of that scenario? No, I don't. I still have my same moral perspective, but from a legal position, I can't make an argument against it. I don't know why that should be unlawful. And will I still vote for legislation that supports the traditional perspectives on marriage? Yes, but I'm not going to do that from my legal brain. I'm going to do that from my moral brain. And I'm going to do that in my own submission to the person of Christ, who I believe is our Savior. I'm not doing that because of my legal brain. And I think that people need to have the ability to kind of perceive things that way. But
okay, so yeah, I think that's good, and like so I'll definitely like post this up on the YouTube channel, and hopefully it will add like a lot more food for thought, because a lot of the responses I've seen on social media have like either the church is in error, it's now teaching gay marriage, or this is evidence of Mormonism's
so ridiculous.
Basically like trying to like gel Jello to the to a wall. It kind of shows how it has like a very soft moral theology and foundation, blah blah blah, a la James White. So yeah, I think this will be like a very good corrective to some of the crap, frankly, that's being produced.
No, it is. It's just there's just a lot of and most of it's coming from people who are trying to either play gotcha, like the what's the one, the God Loves Mormons, what's his name, Bradley, whatever his name is, the kid with the beard.
Yeah, they're all a bunch of idiots there.
It was just like, this is really important that they've changed their. I mean, it's just where. I mean, the number one tool for apologetics, personally, is actually read the document. Let's go back and actually just read that passage. And then they're like, oh, it means this. It's like, no, that doesn't say that. Like the Deuteronomy 18 passage. It's a test of prophets. Well, let's look at the language. And all we can do, because I'm not well versed in Hebrew, all I can do is read the way it's translated in an English translation and just apply whatever meaning I can to it. So if that's what you want to do, because that's all they're doing, well, the words don't mean what you're saying. So if you're trying to say that this is some kind of hard and fast rule that should apply to everybody who's ever pretended to be a prophet, well, you've got a problem, because you're not really like the statements that you gave me when I asked you last week about it. There's a whole bunch of problems. I brought up the one with Samson in Judges, and the guy's like what part of that did he fulfill? He's like, fulfilled prophecy or not?
Yeah, and my favorite is like Micah 3:12. That didn't happen, and then you have Jeremiah in chapter 26 trying to explain why it didn't happen. Contingencies and stuff like that. So
I didn't cite that one because I felt that was too complicated. I didn't want to end up. The person I was talking to, I don't think would have. They'd have been like, "I'm sorry." I was trying to dumb that one down. I'm like, I don't know how to dumb that down. So, I mean, I understood the argument, but I'm like, there's no way I'll be able to explain that in a way that they'll understand. But the Samson one was pretty clear, right? It's like, here's what this is. Here's what happened. We all know the story. Simple. It's like, that's a good point. Yeah, good point. No, I appreciate you doing this. I've been so Jacob Hansen did a video on this.
Yeah, I still have to watch it, but yeah,
it wasn't. It was well-meaning, but it wasn't. And I don't know. What do you think? Was that?
I haven't watched it, so
no. Mine was that good?
Oh yeah. Yours is fine. So, but what I'll do is like I'll add like some notes on the show notes as well. To the press release.
Yeah, I would do links to that and to the summary and things. Yeah, and I just don't think
B.H. Roberts Foundation has the number of articles and research pages dedicated to social issues that touch upon this as well. So include that as well.
I just don't think that people are really contemplating how. I mean, it's often a common problem that I come across with people is I'll just say, What was the original reason that the law adopted the idea of marriage? Why do we have legal marriage? What was the purpose of it?
Yeah.
And this is something I didn't say, but even many states actually have what's called common law marriage. Do you guys have that there in Ireland?
Um,
You know what I'm talking about?
Oh yeah, I know what you're talking about.
Yeah. So there's a specific statute that identifies when two people have entered into what's called the common law marriage. So strong is the state's interest in dividing
No, it's
the
not
products.
recognized here. I just checked.
Yeah.
I've heard of it, but it's never been recognized.
So strong are the desires of the state to make a decision as to who gets your children, who gets your property, and who gets your money, that they've just created common law statutes. And so some things that I do occasionally is I'll take divorces that are literally just, they were never married. They broke up, they separated from one another. The wife took the kid, went down to the attorney general's office and got a child support order, which you can do without a court proceeding, really. And at least not an adversarial proceeding. The court, the AG just kind of believes, okay, you're the biological mom, he's the biological dad, he's on the birth certificate, we'll start taking his paycheck, right? So in the process of doing that, the husband then alleges, oh no, we weren't just boyfriend, girlfriend, we were married, and then sues her for a divorce. And says there's only 3 elements, very simple elements to meet. And so the state has such a compelling interest in interjecting its opinion into those issues that it's just created a statute where you can just claim you're married. You don't even have to file a marriage certificate. And so that's the problem people don't realize is the state wants marriage as its own thing because it wants to control property and it wants to control the destiny of children insofar as deciding their support. And this idea that we shouldn't do that because you don't like gays, okay, fine, but yeah. So.
No, that's good. Well, as I said, I do appreciate your time. So what I'll do is I'll include some of the relevant notes, and hopefully this will be a very good resource. So
cool.
Yeah, thanks again, Travis, for coming on.
No, I appreciate it, Robert. Thanks for inviting me on
for either a stream or another episode in the near future. So
yeah, cool.